discuss about this reverse CIRP. Hope some people would have heard what is this reverse CIRP. It means, are we going to reverse the corporate insolvency resolution process, or what is that? This session, next upcoming slides, we will be discussing on this subject. Actually, this doesn't require 4 hours. I'll try to take up to the extent what is relevant, and we'll close there. We'll just start with a picture. What is this picture? Have you come across this building earlier? Okay, fine. This is nothing.
Yeah? We have not got the picture.
Ma'am, your PPT is showing the first page only, the introduction page.
Okay. One second. Just give me a minute. I'll just try to locate it. Yeah, can you see now?
No, ma'am, it's still showing the blank page.
Blank page. Okay.
Yes, ma'am, now it's visible.
Okay, fine. Okay, these two buildings, one is night view and one is day view. Okay, this building alone is the reason for the CIRP process, the reverse CIRP process. We will just see what does this building has made. It's like a remarkable case law. This has become a landmark building, not for its facilities or other things. It is one which has created the new legislation for us. That's why this is nothing other than Winter Hills. This building is Winter Hills. This is located in Gurgaon. This building alone is the reason for this reverse merger. We will see more about it in upcoming slides. Okay, this Winter Hills is owned by Umang Real Tech Private Limited. This is New Delhi based company. This company is under CIRP process. We will just see the history of this and everything in the upcoming slides. And its resolution professional, still he is an IRP, Manish Kumar Gupta. This case started during 2019. We will just see in glance what is this reverse CIRP process. Reverse corporate resolution process is a kind of resolution process. Here, what is happening is that the promoters of the company, here the company is Umaten, Realtek. So we're allowed to infuse fund in the project as a lender while staying outside the process. This is in simple. If you see what is this reverse CIRP process. See, I'll just repeat. What has happened is that the promoters of the company were allowed to infuse fund. Is it regular in CIRP process? Strictly no. But here that's why there's a deviation, where the promoters of the company were allowed to infuse fund in the project as a lender. Again, not as a promoter, as a lender, while staying outside this process. This process here, it refers to CIRP process. We will see what has happened in this case. Honorable Company Law Appellate Tribunal in Flat Buyers Association, Winter Hills, Gurgaon versus Umang Real Tech Limited has introduced this NECLAT has introduced a concept of reverse CIRP process. What has happened, we will see. The primarily allows the insolvency of the corporate data. Insolvency is not going to stop. It is going to go. How it is going to go? There it makes a difference. Insolvency of the corporate data without the interference of any third party. Who is the third party they are talking about here is that resolution applicant. Without the involvement of the third party, it is just like a compromise. That is corporate debtor on the one side and the financial creditor. Financial creditor here, I refer only to the alloters. In other words, if you see the corporate debtor and creditor enter into an arrangement, just like a compromise to revive the corporate debtor under this process. It is a revival where the resolution applicant involvement is not there. That is the first step. Further, this concept is applicable. We have to see, is this reverse CRP process can be applicable to every industry? As of now, they have made it very specific. It is applicable only to real estate industries. So before going further, delving into the intricacies of Umang Realtek, we will see, we will understand how does the code treats the real estate industry. Okay, these certain things are not new to you. I'm just recapping. I'm just trying to bring how to interpret in a different manner, because the case is that IBC is a 5-year-old code. See, there could be various changes, not only with respect to real estate sector, it could be in any field, because we are experimenting new things. So we don't know, this code is not tailor-made to any specific industry. So it has to be designed, or wherever required, the amendment needs to be made. So I'm just going back. We will just see what is this financial creditors. We will be seeing this alloters and home buyers. Everybody know that this alloters or home buyers are considered as financial creditors. Are they considered as financial creditor at the start of this code? Strictly no. After so many confusion has come into picture, alone these people have been recognized and has been given the status of financial creditor. Earlier there were a question whether they needs to be treated as a financial creditor or operational creditor. Then this confusion was sorted out by Insolvency Law Committee in the year 2018. Code came into picture in 2016. What does this committee recommended? Alloters and home buyers should be classified as financial creditors. Why the new status to them? Why not? We will see that one. How do they have changed the definition to make this alloters as financial creditor? This as deposit. Why is that? As a deposit for purchase of flats and apartments. The nature is that, see, it is considered that these people, these alloters or home buyers, are not buying a flat which is ready to sell. There are cases that some people will buy when the flat is ready to sell. In most of the cases, when the flat is at the inception stage, they infuse fund to the project. Based on the fund alone, construction starts, right? So here they act as a lender for the construction of that particular project. Fine. So that's the reason they are stating that this people needs to be treated in par with financial creditor. I will just read how it has been treated in that manner. Firstly, the deposits made by the home buyers are for the purpose of financing the construction of that flat, correct? Therefore, these type of financial transactions have commercial effect of borrowing. They are saying that the builder is borrowing from this allottees under section 58 subsection 8 F class F. And further, if the flat is not delivered, the home buyers have the right to seek refund of deposit along with interest. Similar to financial institution, if the amount is not paid, they have the right to seek refund. Okay, apart from the flat, that is one side. They have the right to get the amount what has been given along with interest. Okay. Now we are clear that this home buyers are treated as financial creditor. And this financial creditor, and we'll just see in few slides what is the section and what is the definition before going into the case in detail. This financial creditor means any person to whom the financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. So what does it mean? So the person, he would be the real owner of the loan or to whom it had been transferred. Both the parties are covered under financial creditor. This financial debt, if you see, it's a debt along with interest. If any, you just see the word if any represents that even if the interest is not disbursed, it is also considered as financial debt. This financial debt definition has been modified by giving explanation. stating that the amount raised from an allottee under a real estate project shall be deemed to be an amount having a commercial effect on the borrowing. Okay, so whatever we have seen in the previous slide, they are giving the thing, they have the commercial effect of a borrowing. So since specific things are given, allottees are considered as financial creditor. The allottees, real estate projects, for the expression we need to see RARA, Real Estate Regulation and Development Act 2016. In this presentation, in this session, we will see something about RARA too. Because why RARA is there, why this thing has come into IBC, we had to see, because RARA is one which has been introduced in 2016 for the purpose of what? For the purpose of regulating these builders, because we know very well the builders generally get the amount and infuse the amount, this amount in another project. Instead of building this one, they move to the another one because they may get the land at cheaper price. For some reason or other, the fund was collected from the allottees was not used for the purpose for which it is required. So then they came because there was a default in giving the buildings, flats. Then the time period taken by the builder was also uncontrollable. 3 years, 5, more than 3 years it has done. Certain cases they haven't even delivered at all. So because why? Because they have used the fund for another project. So they could not build it. So there were multiple problems accumulated. Then RARA came into picture. Over and above, again, this IBC has given the new term for them as financial creditor. Even after giving multiple credits to these allottees, sufferer is still the sufferer. We will see how it has been mitigated, what problems it has created. Resultantly, what has happened? Where conferred the right of added to giving this financial creditor, they were allowed to be the part of COC, not like operational creditor. These people are allowed to be the part of COC and duly participate and vote on the resolution plans and other major decisions. Okay. But the case is that we know very well these people don't have any individual right. They have to have their own authorized representative. We will see. This few slides will be talking about Esther year code. That is what the code was earlier. Then we will see what is now. Prior to 2018 amendment in the code, what has happened? This aggravate home buyers has approached RARA, correct, and Consumer Forum. We know this Consumer Protection Forum is nothing but is an addition. It gives additional support to the consumer for the money. But it is no way, it is not derogating any law. It is assisting the law to happen as it is. Because the law has to be executed, right? In line with that, this Consumer Protection Act supports them. The court has ruled that jurisdiction under RARA and CPA. See, when the buyer is not given, the allottee is not given flat, he has two options. One thing, he can go to RARA. Another thing, he can go to Consumer Forum. Both are supplementary to each other. That means I can go to RARA as well as I can go to CPA. That is Consumer Protection, Choose Protection Act also. Okay, now after this amendment, after the amendment in the code, what has happened? The home buyers have additional third right. What is the third right? They can even initiate CAIRP against the company. If my flat is not given, if my apartment is not given, I can go to RARA. I can go to CPA. Otherwise, I can take the other angle also. I can initiate CAIRP process. By that, what will happen? The company will come down. The company has to take since the company will be coming down, they have to be extra precaution because it is creating a fear on the builder. If the thing is not delivered on time, not only interest, not only prosecution, even the company can fall down. So they are creating fear. So now what has happened? The home buyers have the right to initiate CAIRP process. We'll see a case. This in Pioneer Urban Land and Infrastructure, this Honorable Supreme Court held that RARA should be read harmoniously with the code. Okay, it is not, we know very well 238 section, which is an overriding, which gives an overriding effect to the code. Whether it is RARA, whether it is Companies Act, whatever it may be, whether it is Enforcement Directorate, whatever be, the code stands as first. And the remedies under Consumer Protection Act all are concurrent remedies. They talk about only one objective. Okay, the code sets a minimum threshold of 100 buyers or 10% of the home buyers in a project. This is section. This is for the year 2018. This amendment has come. Why 100 home buyers is required or 10% of the home buyer is required? Okay, why the thing is that because we know to initiate CRP process, what is the threshold limit required? Currently 1C. If a flat is more than 1C, a single allottee can approach CRP, right? So it is not, say if there are 300 allotters, at least one or at least 5% will not be satisfied with the building construction or something or some other reason will be there. In that case, if a person, this 1 crore is given as a limit, that is alone threshold limit, then we can see multiple companies will be under CRP process. To curb that, to stop that, mitigate that, what has happened is that the code has set the threshold limit, at least 100 home buyers or 10% of the total home buyers in a project, whichever is less they are given. If it comes if the home buyer for the particular project is 100, then 10 will do. Either 100 home buyers or in the particular case 10, whichever is less, those people are sufficient to trigger CRP process under section 7 because they are financial creditor, right? But if you see the 10% will take up this code, right? But other 90% can approach any other forum. Can they proceed in that? No. Why? Because once the CRP process starts, moratorium starts. So whatever initiated under other code, other law stands still. Okay, now the next thing we'll see is that the CRP process is mandatorily completed within a period of 330 days from insolvency commencement date. Why 330 days is given here? Because we very well know 180 days, plus I can go for a one-time extension of 90 days. And why this balance days? Then it comes to 270. Here they are making it concrete. Whatever reason you say, you can't exit 330. What is that whatever reason you say? Because see, in case there is, we know limitation period is there. If sometimes something happens because of this thing, limitation period, in some cases there, some hearing is there, then in that case, those days are not considered for this 180 or 90 days. Considering that also, whatever hearing in NCLT, maybe you consider that also, but in no way it cannot exit 330 days. That's what here. Thus, still during the duration of the proceedings, another forum remains suspended. We know this very well. Apart from getting right to initiate CRP process, what has happened is that we have seen earlier, they have the right to be in COC. Because we know operational creditors, they don't have right in COC. If giving the special nature as financial creditor for allotters, they have, the thing is that they can be as part of COC. Okay, which forms a decision-making body in the CRP of a corporate data. This is the thing, we have seen this also. This we have to represent only through authorized representative. Alone we can represent. That's what with regard to this allotters. Okay, there is one more ordinance which has come, 2019 ordinance. What does it say? What does it say for this home buyers? Yes. Here, in line with 2018 alone, but they have modified certain words. They have included certain words. Either 100 in number or 10% of the allotters, whichever is less, of a same real estate project. Why the word same real estate project is given? Because case is that because a builder can develop multiple apartments in multiple places in multiple states, right? In that case, they say it is not that various projects needs to become together. Particular project, if a particular project which has more than 100 allotters, 100 will do. Our 10% of the total allotters of the particular project can take it up. Take up a company under this CRP process. Ordinance was also extended to CRP application. One more thing they made in this 2019 ordinance is that even the one retrospective amendment has been given. This is another one. A retrospective amendment in the sense whatever hasn't been accepted earlier can be accepted. Okay, here Manish Kumar Gupta, who is the resolution professional for this case also, which case? Winter Hills case. Okay. Uma Tangriel Tech case also has challenged this one. Why? Project between project. Is it not that Article 14 of the Constitution is deviated? What does this Article 14 of the Constitution says? First thing we will see. This Article 14 says that equality, equal importance, equally everybody is treated equal. That is what Article 14 says. Here they are giving same real estate project. If a company has multiple projects, in that case, they are asking at least 100 in number of the particular project or 10% of the LRT. If they are fine, they can initiate the CRP process. Then in that case, here Manish Kumar, resolution professional, has questioned this one, constitutional bias of this amendment. On the ground, it creates class within the class. Then the second thing was also this retrospective application was also challenged. Thereafter, what is the Supreme Court judgment? Supreme Court said in this matter, issued a notice of status quo with respect to pending application, thus allowing retrospective application of the amendment for time being. They have said, even if it is old one, it can be accepted. Okay. We can't say the Limitation Act is applicable, we can initiate here. And they have said class within class, it is not against Article 14. That was a judgment which has been given for this amendment.
Ma'am, just a sec.
Yeah.
If you could kindly go back to your previous slide.
Okay.
It has only the notice has been issued by Supreme Court. The judgment has not been passed.
Which one you are saying with regard to Manish Kumar and this one?
Manish Kumar versus Union of India.
Okay.
I think only notice has been issued, not the judgment has been passed.
That's what, issued notice of status quo with respect to pending application, that's disallowing. And they have given the notice stating that it is disallowing retrospective application of the amendment for time being. So what they have done is that, as you said, notice has been issued and they said retrospective is not possible for time being. They haven't come with the conclusion, they have given a notice.
Secondly, what is the violation of right to life in this ordinance? That I could not understand.
What is that?
You have said it has also been challenged on grounds of violation of right to life.
Not to right, Article 14, equality.
No, you have also said the second ground is that the retrospective application of the amendment is unconstitutional. And finally, it has been challenged on grounds of violation of right to life, which is where I was confused.
Okay, fine. On the grounds of violation of right to question. Actually, I'll just modify this one. The thing is that it is the case is that if you make retrospective thing, here the thing is that there are cases. It is not the current one, right? There are multiple cases which is pending. If we take up those cases, even the company may not be there. So that is a problem. We will not be right. Will not have a concrete solution for those things. Okay, we will see the next one. What is this RERA doing? RERA has come in support of this home buyers LRTs alone. Okay, fine. Why RERA couldn't do? Why this IBC has given the special character of financial creditors? We will see. What is this RERA? See, what RERA has been brought to exclusively for real estate sector. Okay, to make it transparent and to eliminate fly-by-night operators. Because we know very well they collect the fund from the builder, from the allotters. Then after that, no land has been constructed. Land will be vacant for years together. The sufferer is allottees. Right. To curb that, to mitigate that alone, RERA came into picture. RERA's main thing was that it delay in possession of their homes was possession was delayed. Right. And moreover, we have section which says income tax section, which says that we have to buy the house within 3 years time or construct it within 2 years, buy the house in 2 years time, construct the house in 3 years time. Those things are there. Right. If there is a delay, then will not the person who has taken the house will be deprived of income tax benefit? Right. Because these people, instead of 3 years, they take 5 years, more than yet. Sometimes they don't build at all for some reason. Okay. This delay in first thing, RERA was formed to address the delay in possession of their homes has been the biggest concern of buyers of the real estate properties. For many home buyers across locations, not only in particular state, it is in multiple locations. Delay has extended almost to 6 years or even more. Possession, some cases, if you see, there is only a barren land. No construction has started earlier. Okay, in absence of regulator, with no rules in place, the builder by a battle appeared one side. They keep on questioning the builder. Builder will not answer. To curb that, RARA came into picture. This RARA has got its real estate sector has got its own regulator. This RARA came into picture on 1st May 2017. See, this RARA didn't come immediately. It came after the wait of 9 years of this because the problem were multiplying in higher number. But this RARA came after 9 years. Okay. And RARA become effective for entire country. And moreover, RARA is specific for each state. The rule is one and the same, but for each state, they can modify to the extent to their requirement. Okay, it is applicable state-wise. This RARA is applicable when it is applicable when the minimum ground size is 500 square meter or 8 apartment needs to be constructed in the particular land. Either of this case, in this case, we have to go and get approval from RARA. RARA is an additional approval. After getting approval from CMDA and other thing, we have to get approval from RARA also. The developers needs to get themselves registered there. Okay, once it is registered, they have to follow the rules. Apart from other rules, they have to follow the rules and regulation of state RARA thing they have to follow.
Ma'am, I am disturbing you once again.
Yeah.
I have just put on the chat box, at the address of a website. And I'm not too sure whether I'm right, and that's why I'm seeking that clarification.
No problem.
This is not to challenge anything.
Doesn't matter.
Seems like in that judgment case, Manish Kumar Gupta, the order has come. It's not only notice, and Supreme Court has upheld the amendment. So am I reading the wrong matter, or that's why I've given the, on the chat box, the address of that website, Manish Kumar versus Union of India. If you can see in the chat box.
Yeah, I'll see and I'll revert you very shortly.
Thank you. Thank you. I'm sorry but I just wanted to clarify clear picture.
Yeah, ready to take. Okay, fine. I'll move here and I'll come back to you and I'll address you today itself. Okay. The real estate sector has got its own, we have seen these things, we'll move to the next one. Okay, what is this RARA? What are the main things which RARA has given us? We will see. Return affidavit. That is one thing. Then possession date will be sacrosanct. Then clear title of land, free from encumbrance, maintaining separate account, make it an offense. So these are the 6 provisions which RARA has given. We will see in detail what is this written affidavit, possession date to be sacrosanct. Those things we will be discussing in this upcoming slide. The promoter promises, that is the builder promises that they will give a written affidavit. What is the written affidavit? Apart from other regular documents which they are supposed to give as a builder, that is parent document, blue sketch and other approval thing, they have to give a written affidavit. What is that affidavit has to say is that they have to specify the time period within which the project or the specific phase will be completed. They have to give the clear thing. Why this affidavit? Affidavit has a legal standing. So that's why they are saying that apart from your regular agreement to sale, you have to give a written affidavit stating that the time period within which the project or the specific phase will get completed. Then the next thing is that possession date. Possession date needs to be sacrosanct. That means it has to be very vivid. It must be very clear. In the agreement for sale, that is the first document we will be entering with the seller. Specify the date of possession and the rate of interest in case of any default. That is also, see, when you buy, we have to see for these details. Okay, for new projects, committed delivery of date of delivery is a choice of the developer. See, he can say 2 years, 3 years, 4 years, even some cases he may say 5 years. Okay, then once it is specified, then it becomes clear for us whether to take up this apartment or not to take up this apartment. Here, since it is clearly specified, if not undertaken, we have the legal thing to sue them. That being the case, now it is in the hands of the customer to take whether to buy it or not to buy it. So these things will give us some clarity, right? The next thing is that clear title of land. Why the clear title of land is given? Earlier, before RARA and in older days also, there are cases where a single land may have two documents, more than two documents. That means a land can have the ownership of more than one person. Then what will happen? The other person, suppose the land is there, a person is a owner, A is a owner, and the building starts creeping, then the B will say, this is my land. I have the document. So in that case, the RARA says that if a buyer says he has registered under RARA, it means he holds a clear title of land. And if there is any dispute comes, it is his responsibility to sort it out, and the buyer, the allottee, is no way responsible for that. That clear title of land is taken care there. Then free from encumbrance. See, we know we can check in our EC, encumbrance certificate. We can see whether who is the owner of the land for the particular date. We can check, right? Sometimes some problem has happened in the earlier cases. So what is the case is that free from encumbrance in the sense, this land does not have any loan or no other mortgages there. That's what this RARA states, that once it is registered, that particular land is free from encumbrance. That because of this, sometimes what has happened is that once a construction has started, the land may get hold, construction may get hold because of the clear title may not be there. Sometimes the person may say it is already encumbered, already mortgaged. You are not supposed to construct here. To avoid this problem, once it is registered under RARA, these problems are sorted out. Then the next main thing has happened is that maintaining separate account. Earlier, what was the problem we were seeing? When the fund comes, the builder divert the funds. If the comes in for this Winter Hills, he has diverted the funds to another thing, another project, to buy the land or to do the construction. So fund will come from A project, he will use for B project or C project. He moves on, the fund moves on to different projects. But the buyer who will be having an idea, this particular project will be completed. So to curb that, to stop those things, what has happened is that RARA said, if a person gives 100 rupees, 70% of the amount, that is 70 rupees, needs to go to a special account, that is escrow account. Okay, that is real RARA account. We call it as generally RARA account. This 70% of the amount needs to go and hit that account. Only 30% can be used for some other purpose. This 70% needs to be used only for constructing that particular project. We'll take it as project A. And it has to be maintained, not in, they have specified, it has to be maintained in the schedule bank. Purpose is that to cover the cost of construction and land cost and shall be used only for that purpose. How do we know whether it is used for only for that purpose? We will see that one. Any withdrawal from that account will be according to the extent of work completed. So here it stands. See, the thing is that once account has 70 lakhs, withdrawal is permitted only after it is certified by an engineer, architect, and a chartered accountant. Unless these three persons certify that, it cannot be taken out. Further thing is that it will be subject to an audit, right? Or then an auditor, he needs to give a certificate that the amount has been expensed in line with the thing what they have communicated. Okay, such measures to large extent are expected to minimize the diversion of funds, if not in fully, at least to some extent, because they at least 70% of the amount what is received from the allottee needs to be used for that purpose, right? Okay, then the last category is that making it as an offense. What is an offense? Here, if I'm not adhering to the rules, the builder stands not only to lose the registration of the project, but also registration of the project will go. So he cannot continue the project, but may also be punishable with imprisonment for a term of 3 years. And the fine or with fine, which may extend further 10% of the estimated cost of the real estate project. Or it can be both, imprisonment as well as fine also can be there. In summary, we will see what is this RARA has given us. See, if you see, if a builder is constructing, in that case, in his website, he has to publish the number of plots for a particular project. Types. What is the type of the plot? Then status approval, it has to get multiple approvals, right? So which stage of approval it is there, that has to be specified. And the project status in the, when it is under construction, also they have to publish the thing, which stage of the project the construction is there. That one needs to be given in the website of the builder. Then the next thing is that allottees information, sanctioned plan, layout, scheme of completion, those things needs to be given. Our next main thing is that without getting approval from RERA, no advertisement is permissible. So whenever advertisement comes, it means they should have obtained RERA. If without obtaining RERA, no advertisement is possible. And we have seen this 70% norms to be fulfilled. All civil approvals needs to be obtained. Then the thing, another case is that the defect liability. If it is RERA approved, it will have defect liability. Defect liability is not for 1 single year. Defect liability is for 5 years. This 5 years, that will be that when a defect is notified, in that case, it has to be rectified in 30 days. See, this is different. Doesn't mean this every defect will be addressed by the builder. If it is major structural problem, in that case, they will identify. They will address it. If it is a smaller one like crack, those things they will not, that will not be addressed in the defect liability. Then, as I said earlier, we have to get the advertisement is permissible only after obtaining RERA. Commencement certificate is required, sanction plan is required. Then we have to get the complete details of the unit. If a construction has multiple phases, which phase they are, what is the stage of completion? Those things should be specified then and there clearly. That means, what does it mean? Sitting at home, I can know what is the stage of my particular project. That's what RERA expects from a builder. Legal title of the land of the project, that what we have seen, it is any problem, it is a builder to address. No way the lottee will be entering into such problem and his construction will keep going. And any other documents, whatever documents they are saying, that has to be taken care. RERA has come, but why not again the problem is keep on coming? We will see that one. Okay, RERA gives the house buyers a choice to get either they can get the interest or on delayed possession or complete refund of the amount paid along with interest. This, if you see this complete refund, there will be a mismatch when compared to IBC. We will see that one also. I have to get the option is there. I can get interest on delayed possession or I can get the refund. In case the builder decides to change the project possession date, then the buyer can legally withdraw from the project. Possession date is changed. Again, it's not the blind reading of the word possession date change. Thing is that if it is outside his control, what can he do? During COVID, he can't do anything. So whatever it is under his control, but he couldn't do it, then the buyer has legal stand there. And the case is that the refund to be paid within 45 days of the claim. That is also there as per RERA. If the buyer does not withdraw the property possession, then the builder will have to compensate the buyer for the delay in the form of monthly interest till he hands over the property. That's what interest needs to be paid for the delay, because you see, I would have taken a loan and I have to pay interest or EMI there. Fine. Added to that, I may be deprived of my income tax benefit if I'm taking some exemption under Income Tax Act. Then these things I'm deprived, right? So at least I'll be compensated with some monthly interest. This is also given in RERA. What if builder delay the possession? Further to that, apart from claiming interest, apart from going for a refund, I can file a claim with the adjudicating authority appointed under RERA. So that is also there. Now we will come to what is this insolvency and bankruptcy? Now where does it stand? And we will see this IBC as well as this real estate sector. See, we will just see in few slides what is the trend of IBC. We know, everyone knows very well, the IBC came beginning of December 2016. Okay, until 31st March 2022, only 47% of the corporate insolvency process went into liquidation, and compared to 14% has ended up in the resolution plan. So it means 47% has taken a liquidation route. Only 14% has taken a resolution plan route. That means that even after IBC has come into picture, the liquidation route is more. Before, if you see a SARFAESI, it was 75%. Now it has reduced and it is 47%. This is where we stand right now. But here again, the sad part is that it goes to liquidation. What is expected with regard to IBC? What is the objective? It is only first thing is that we have to get a resolution plan. We should get someone needs to buy this company and take it go, make it a going concern. That was the real objective. But in practical, the most of the cases, it is not happening in that manner. If you see, out of total 5,258 CRP process initiated, out of 5,000, 3,406 has been closed. How this is closed? Is that they have found a resolution plan route? No. Out of that, 1,609 is have ordered for liquidation. Other 480 alone have got a resolution plan. That means, see, the buyers, a resolution applicant are not willing to take up this property under CRP process. The reason could be many. Some cases, what is the case is that in most of the company which is under IBC, the company doesn't worth at all. That means the company's asset has been already sold. Okay, or doesn't have any, if to buy a company, we have a resolution applicant will see, is it fruitful for me if I buy, right? If it is completely eroded, what shall I do? No purpose of taking it, no, then the company will automatically go into liquidation alone. See, if you see in general, as of now, out of the total debt, only 8% alone seems to be realizable. To that extent alone, asset is available with the company. This is the stand right now in India. It's a poor scenario alone, we have to see. Okay. Most of the assets going into default, particularly if you see the gas-based power plants, people, no buyers are there. Why? Because, see, having the gas-based power plants, to maintain itself, it's very costly. Then how to buy this? And because another thing is that there could be industry, there could be machinery, but we couldn't buy it. Reason because the gas prices are increasing day by day. So the profit margin is less. This is the case of one particular sector. In some cases, it is not the case of all the cases. We don't have good assets. There are exceptions also there. I say it as exception because it is not general. For example, Bhushan Steel, resolution was fruitful and haircut was relatively low. Haircut in the sense because nowadays what has happened is that the banks are ready for haircut. Haircut in the sense they will be, if 1,000 crore is a loan, they are ready to accept even 200 crore. That will do for them. These things are happening in the real world. Okay, but in cases, there are Bhushan Steel is quite good one, but in cases where assets are not very useful or they have been depreciated, there will be a large mismatch and the liquidation is the only option. That's a right go right. See, if you see the large cases which is admitted under IBC like SR Steel, Jet Airways, Diwan Housing, they have been resolved only to certain portion as haircut. If you see Jet Airways, 95% haircut is there. So that is the right now the trend of IBC. See, this goes on where we will not, it is not the, some cases a resolution application is benefited. Some cases it is let it die. That's the way liquidation comes into picture. When the company has no asset, no employees, no customer base, what is the purpose of buying the company? Some cases the company has survived even without sufficient fund for years together. Now we will see this insolvency and bankruptcy code and our particular case. Now we are moving to the case which gave us reverse CRP process. This case is dealt in National Company Law Appellate Tribunal, New Delhi. Okay, this Flat Buyers Association Winter Hills. Winter Hills is the project name. It is in Gurgaon versus Umang Realtech Private Limited. Justice, who is the justice of this? Mayopadhyay. He was a justice from the inception of the court till 2020. Till June 2020, he was a justice who was handling this IBC cases. This CRP process started for this Umang Realtech on 20th August 2019. The applicant, we will just see who are the applicants, and there was a change in the case when it came to NCLAT. We will see those things in detail. Original applicant is Rachna Singh and Ajay Singh. They are the allotters. They together alone initiated the resolution process. And the resolution professional is Manish Kumar Gupta. We will see the case now. Before catering into the case, let us have some question in our mind. Let it go on the background so that we'll try to get the answer for such questions. First question is that whether CRP processed against the real estate company, we are talking here only about the real estate company, is limited to a project as per the approved plan by the competent authority and to other projects of the company which are separate, which are in other places for which separate plans are approved. That means the first question is that whether CRP process is for the particular project. For example, a project, or it is applicable to all the projects of the company. If the company has 5 projects, A, B, C, D, E. In that case, is it applicable to all projects? That is the first question. We'll go on to the second question. Whether if the same real estate company has any other project in any other town, can they be clubbed together, or the assets of the corporate data for such other projects be maximized? See, a project is in one place. For example, it is in Gurgaon. Another project is in Jharkhand. Is it necessary to get? Is it necessary the 2 projects needs to be clubbed? That also a question arises, because a company can have multiple projects, 20 projects, 30 projects running. If a project has created an issue, is it necessary all the 20 will come under that category? How is that? We will see that question also will be answered. Okay. Next thing is that in case of CRP of the real estate company, a secured creditor such as financial creditor, financial institution, bank can provide with an assets by preference over allotters. See, financial banks are also financial creditors, allottees also financial creditors. Who has to given preference? Whether financial creditors, this allottees, or the financial institution. Who has to be given preference? That is also be answered. Next thing. Next question needs to be checked is that while satisfying the allotters, okay, I have decided to satisfy the allotters. One or more allotters agrees to opt for another apartment. See, he feels he wants to take up the another apartment in the same project or in the different tower. It could be in the different phase. Whether that can be allowed or whether he can climb. Next thing is that whether he can go for a refund, where the allotters ask for the refund, that prayer can be executed by NCLT or appellate tribunal? That is another question. For whether after completion of the plans or projects or during the completion, okay, here first scenario, whether they can move to NCLT or NCLAT for refund. Or the last question is that whether they can approach the promoter itself for refund. These 6 questions will be answered. Okay. Before getting the answer, we will just see what is this background, what is the story of this one. First thing is that this corporate data, Uma Realtech, is involved in the construction of flats, right? Winter Hills 77 stood substantially. Here the case is that Winter Hills is a project which is substantially completed. It is about to complete, right? If it is allowed for 6 months or 8 months, it should have been completed. And the major dues of other financial creditors also cleared. However, few allotters who had made timely deposit, that is based on the basis here they have done the deposit, they have been given allotted flats as per the time specified in the agreement to sell. They have been given. So what they have taken and the steps they have taken is that they have filed an application under section 7 of the code against the corporate data. Okay. Subsequent to filing, once that filing has started, that means this case has been admitted by NCLT. So that is the scenario stands there. After admitting, what has happened is that one of the promoter, here the scenario is entirely new. It is not the one which is said in the code. One of the promoter, Uppal Housing Private Limited of the CD, that is corporate data, one of the shareholder, that is one of the main shareholder promoter, intervened and said See, he is ready to infuse fund to complete the project. But he is saying he is intended to play the role of the lender, financial creditor, not as a promoter, to ensure that the CRP reaches success. Okay, and given the position of the and give the position to the allottees. Which this what has happened is that after the CRP process has been initiated, this story started. This is a new story which is not an expected one. The promoter, one of the promoter, Upal Housing, he said he is ready to fund as a financial creditor. And he is ready to ensure that the project is completed and to give the position of flats to the allottees. He has come out with a different approach. Now, the question is that whether this can be accepted or not, because this is not what is stated in the code, right? In the light of the same, the applicant allottee did not accepting that this applicants, what is they also accepted, because end of the day, those two people want only the flat. It is not that they want a company to come down. So they agreed for this. That is applicant allottee did not want the submission and approval of the third party resolution plan. Here they are made it clear. This applicant made it clear. Support from the other side also. The promoter is ready to support. The person who has made the application, he and she also agrees that we don't want the third party. Let the promoter complete it. As prescribed in the CRP process, the resolution applicant need not to come into picture. Therefore, the issue that before, now the question they have moved to the NCLT. And ECLAT they have moved. Whether such reverse CRP process could be adopted. This is the first different move started here. And then it goes again. During this, things happen during the CRP process, that is before making petition to NCLAT. What was further to this Upal, another person is also ready to fund this project. Who is that? JM Financial Credit Solution. He is a financial institution. They are agreed to cooperate. Only one condition. Whenever the fund comes, they have to be given 30%. Whenever the fund comes from the allottees, that is further fund, they have to be given 30%. That is only one condition. And he is also, this financial institution is also ready. Okay. These are the allottees, that is Rachan Singh and Ajay Singh. They are the person who has made the application under section 7. Okay, joined hands with the Flat Buyers Association. The association is generally formed. Here, these people who has made the application have also joined hands with this association and become its member. During the last few months of the CRP process, has progressed, a number of allottees, including have already taken, see, before this period, this 180 days has come into close, these people, Rachan Singh and Ajay Singh, have already taken the possession of the respective flats. They have been given, what else? See, my requirement is fulfilled by then CRP process. Okay, these are the questions running. We will see. Have been registered in their favor. Before the close of the CRP period itself, they got the flat. In the light of the same, the applicant allottee did not want the submission and approval of the third party resolution. DRI doesn't want. So they have moved to the NCLAT. Okay. Then we will see furthermore, the numbers of these winter hills, so that we can clearly understand the case, and added to that, we can apply the situation in other scenarios also, and we can enlarge our interpretation. With this Upal Housing Private Limited, which is also accepted and endorsed by Manish Kumar Gupta. He is an interim resolution professional. He is quite supportive. Okay, in this case, that is Winter Hills. How many flats were there means 706 were there. Out of 706, 624 flats were already booked or agreed to be sold. This were there. Added to that, during the CRP process is a positive note. During CRP process itself, they had 3 bookings. Okay. The corporate data offered to all 624 allottees through interim resolution. In this interim resolution professional has taken the role of directing, that is managing the show. 624 people have been allotted, offered the position. Position has been given. This is one scenario. There are 453 number of allottees. Out of the 624, we will see further cases. 450 number of allottees who have paid they have paid the consideration in full. And they have taken the position. 26 allottees, what has happened? They have paid in full, but they haven't taken the apartment. That is one case. 453 is clear, 26 also clear. Then the next comes this 142 allottees. They have booked the apartment, but they haven't paid in full. Their installment is due. Okay, this IRP has issued demand notice to make the payment of outstanding payment. However, some paid, some neither paid. Some confusion was going with regard to 142 alloters. Okay, that is the story behind that thing. So they have constructed, okay, and Upal Housing has come as a promoter. He's ready to infuse fund, and the fund has been infused even before the CRP process. The project has been completed and possession has been taken. That is the scenario. Okay, this is well good story alone, quite accepted. What next? We will see here. Now we have to see the ruling of NCLAT. Whether they accepted this procedure or they said no to this because it is not as per the directions given in the code, we will see here. NCLAT, what does it has said? It does this they have given, they have specified it, this is applicable only to a real estate sector. If allottees, that is financial creditors, financial institutions or operational creditor of one project initiated CRP process against a corporate debtor, it is confined to one project. They have given a thing, if CRP process has been initiated by the allotters or financial institutions or operational creditor, it is restricted to only that project. It is not against the company. That is, if it's against a project, it is against a project alone, not against the company. That is a new stand they have given. The first stand. It cannot affect other projects of the same real estate company. Okay. In other places where separate plans are approved. Here, separate plans doesn't mean resolution applicant plans. Separate plan refers to plan approved by the concerned approving authority, like CMDA. So many authorities are there. Like that thing, it is different thing. Okay, by different authorities. Land and its owner may be different and mainly allotters, financial institutions. Maybe, for example, if a project is, it could be a project. If the project can have separate allotters, alone. Financial institution is different. Operational creditor is different. Everything is separate. That is, this project stands on its own. It is a separate undertaking. In that case, it is clear. Okay, it is good to adopt here. Therefore, all the assets of the company are not to be maximized. That means leave the other projects. Only project which has been allottee has filed a CRP, it is applicable to his project alone, not to other projects. That's what the thing they have given as a first thing. Other need not be maximized. If there are problem in other, let it go. Okay, the assets of the company, corporate data, the real estate of the particular project is to be maximized for balancing the creditors, such as allotters. In that is the one which needs to be considered. That is the ruling given by NCLAT.
Madam, may I ask a question, small question?
Yeah.
If you can. So, ma'am, maybe I'm asking a silly question, but as a RP, I'm responsible for the legal compliances of the corporate data, including filing of MCA returns and tax returns.
Correct.
Now, in this case, when the RP is only against the real particular project and not against the full company as such, what you are saying, and how will he discharge those legal compliances, or is he relieved of those obligations?
Yeah, your question is still valid. Your question is answered in the next slides. We will see right now. Since you have put this question, I'll answer here to some extent, not in large. Okay. Case is that here they have stated that it is applicable for a particular project alone. If we had to see, if a company has ABC, I'm taking the case of ABCD project alone. Out of that, A is only can be revived, because in this case, Winter Hill case, this is in almost completion stage. BCD, if it is in the start stage, this will enter into CRP process, and CRP process will continue. The RP needs to continue with the regular CRP process. Only A is reversed. This is reversed CRP, A is reversed CRP, BCD. Okay, it will take the normal CRP route. This RP will play a two role here. One is with regard to A, reverse CRP, for the others, regular one. As you said, he has to fight. Here some issues are there, which also we'll discuss. Okay. Your name, please.
Kanti Mohan Rustagi.
Huh?
Kanti Mohan Rustagi.
Gandhi. I'll just say you Gandhi. Okay.
Mohan.
Fine. I'll address your question furthermore because that are the things which are the problems, real problems it is faced. Okay. Further, secured creditors such as financial institution, banks cannot provide the asset by preference over the alloters. This is very well known. The second thing they have said that is that only alloters to be given preference, not the 50, not as per section 54. So even though they are secured, alloters will be given first preference for whom the project has been approved. Their claims are to be satisfying by providing the flat or apartment. Okay, that's what it is given here. In the ruling, it was given. While satisfying the alloters, one or more alloters may opt. Okay, first thing here. Okay, first thing I'm satisfied. Next, the allottee are given furthermore option. What are the options? Because if I see, I have chosen west facing apartment. Later, I have changed my mind to have east facing apartment. Can I change? Yes, they are saying the after satisfying, my allotee may agree to opt for another flat or apartment or other tower or one or other tower, if not allotted to any other. In that case, if it is not allotted, even these allottees are given right, they can get their thing. Okay, this interim resolution professional needs to modify the agreement along with the signature of the promoter. The cushion is given to them. Further enhancement, further cushion is given to these allottees. Okay, because why this cushion is given? Because these people are paying rent, paying interest, and paying interest EMI, but they are not given apartments. So to avoid that alone, this special stand has been taken for them. That is there. This extra cushion, they can even choose one apartment instead of another apartment. That is also the cushion given here. Okay.
You could go back to the previous slide. I still am on the first para. You are saying
this slide or other slide?
This slide only.
Okay.
In the first para, in the first sentence, you are saying the financial institutions bank cannot be provided with the asset.
Correct.
In the second sentence, you are saying their claims are to be satisfied by providing the flat apartment. So
it is
clarity between the two sentences.
I'll explain you. This first line talks about the secured creditor. That is talks about the bank. Here, what they are saying, we know very well secured creditor needs to be given priority, right? But here cannot be provided with the asset. The first line, banks or financial institutions, they could have been loan some, right? They will not be given asset or apartment by preference over the allottees. That means their money will not be given first. Only allottees will be given their apartments. So here, what is the thing is that secured creditors, even though financial institution, they are suppressed here. Only allottees are the first preference with regard to real estate sector. That's what they mean here.
And then the banks and financial institutions will get their flats after the
after allottees has been fulfilled. Here, this is the judgment which has been given in this case, which is subject, which has many controversies, which we will discuss. Because if you see, this is not the right one, which is not given as per, it is not as per section 53, right? This is an issue alone. But here they have taken the stand. Because the case is that this code provisions is not tailor-made to a particular thing. Here, in this case, they are making it in line with that particular Winter Hill situation. And as such, if you see in all real estate sector, only allottees are given first preference. Okay, even a particular few assets are mortgaged by this secured creditor. In that case, they are not given any preference. First thing is that allottees. Okay, can you move on?
Yes, please. Sorry.
Okay, fine. The next thing comes the refund. See, the person, first thing, allottees needs to be given preference. Then second point is that they can interchange flats, and they can even go for next tower, which is not given earlier. That question is given. Okay, the third question is that will they be given refund as specified in RARA? Okay, here it takes a different stand. There may be some allottees who may ask for refund, but the prayer cannot be allowed by NCLT or NECLAT. Why? Why not? Because it is said in this pioneer urban land and infrastructure case. Okay, the point before moving into that, I'll just touch section 65. What is the section 65 of the code? Okay, these are the penalty sections. What does it state? Suppose if a person takes up this code, okay, with an intention, with a fraudulent intention to bring a company down, in that case, it is not fair on his part, right? If something has happened, if a person is doing in that manner to bring the company down to get the amount, it is not to be accepted. So that in that case, he will be imposed with a penalty. That's what section 65 says. What does it say? If a person brings out this insolvency process under the code fraudulently with a malicious intent or for any purpose other than resolution of insolvency, in that case, the code doesn't support him. He will be imposed penalty. Okay. Then similarly, if a person's intention is not to come with a resolution, not to come with a solution, his thing is that to get refund. It's a refund is fine, but the refund is not a real notion, because whenever we are buying an apartment, we are willing to buy an apartment. What is to get the apartment? It is not that thing. I will get the amount. There could be a situation when the people may come for refund, ask for refund. In that scenario, what is it stated is that in the real estate developer may do by pointing out, for example, that the allotee who has knocked at the doors of NCLT is a speculative investor. Just to create some problem, these people join hands together. 10% is a smaller number. 100 numbers is okay. 10% is a smaller number. So if they had an intention, then they are not genuinely interested in purchasing an apartment. In that case, they can take up this route, right? To stop that, to curb that. What does they have done is that they said refund will not be permitted. Okay, because for this purpose alone, they said refund will not be given. You will be given apartment. That's what the stand here taken here. Okay, after considering this, NCLAT has has upheld the application of reverse CRP process. So what has been happened is that NCLAT has accepted the reverse CRP process and held as follows. What they said, application for reverse CRP process, that is, can be resolved if they are saying without the third party intervention, that is without the intervention of the resolution applicant. If the promoter and the resolution applicant agreed, then in that case, it can take a new route which is not specified in the code. Okay, that means the project can be completed. That's what it is specified in the it was specified in the ruling. It primarily relied on the decisions. They have taken this decision also. Pioneer Urban Land and Infrastructure versus Union of India to justify their decision. To say my decision is right. Their decision is right. They have taken the impact from Pioneer Urban Land. What is that thing is that judiciary has sufficient power of experimentation in case of economic legislations. We will just see the terminology. You people very well aware of it. I'm just saying, just to recollect, what is this judiciary? What is this executory? What is this legislative? These three are the organs of the government, right? What is this judiciary? What is this legislative? What is this executive? That's what I'm going to say now. What is this legislative? These are that part can make laws. Legislative can make laws. Executive, they execute the laws. Judiciary, what they do, judiciary are none other than the court. They ensure that the laws which is specified by the legislations are correctly followed, or there are any deviation from the law or act. That is one thing which is the judiciary has. Now the NCLT and NCLAT has judiciary power. What do they say here? The judiciary represents NCLAT and NCLT, has sufficient power of experimentation. This is most important here. Experimentation in case of economic legislations. Economic legislation in the sense it is of commercial thing. Here we say an IBSC as a commercial, as a business oriented law. It has nothing to do with civil or criminal. So they say that on the ground, judiciary has sufficient power of experimentation in case of economic legislation. So they can experiment things. Experimentation in the sense what is not specified in the code has been taken here. They are saying Supreme Court has justified the ground, judiciary has sufficient power of experimentation. Okay. Further justification was also premised on the assumption that in most cases, COC takes a haircut. Correct. COC takes a haircut. How can the allottee take a haircut? Accepts a sum less than the original due. Correct. Is it possible for the allotters cannot take the haircut? So they are allowing here, but it is not the case with all the projects. Some projects, they have to haircut in the sense they would have invested 50 lakhs or 1 crore. They may get 20 lakhs. They have to accept it because this scenario is not applicable in all cases. So they have given this statement in this NCLAT, but still it is questionable. Okay. See, what is this? See, the process of CRP should be project specific based on the plan approved by the competent authority. So they want this CRP process with respect to real estate sector to be project specific. They are making it little more. Okay, if you think it has more pros as well as cons. If a project specific, because instead of stepping other projects, I can go and hit the thing which has only problem. Other way to say is that if out of 10, only 8 has problem, 2 is ready to go, let 2 to let go. We can take this as 2 ways. See, suppose only 1 is good, take up the 1 and do reverse CRP. Out of 10, 2 is ready to go, take up 2. Rest 8 will go for normal CRP route. So I can go and hit only the project where which has been funded by me. The entire assets of the corporate data need not be maximized. It is not necessary the entire 10 needs to come. That's what this reverse CRP says. Only the asset of the specific project should be considered and maximized. Where the problem, hit that problem alone. That's what this means. So if the operational creditor and the financial creditor of the particular project A, let them alone take up, let them alone be considered for that particular CRP process. That's what the new route which is given here. Okay. Now we will come to Gandhi's questions earlier, which he has asked. Secured creditors cannot be given preference over allotters or home buyers in case of allotted flats or apartments. Correct. This is also the ruling which is given here. Allotters and home buyers are barred from claiming refund under the code that we have seen. A refund can be sought either by it's not that refund is completely neglected. Here they are giving a cushion. They have given the cushion in the ruling. What does it say is that if I want refund, my refund is very genuine. In that case, is what they are saying is that for your apartment, let the resolution professional find another buyer. Once another buyer is found, your fund can be given. That is only the case. It is not that the entire thing to be given refund. It is not that. It is very specific. They have addressed that question also. In the light of the above, what is the case is that okay. Well, giving the ruling, they have given the some more timelines also to complete the rest of the project. Specify timelines also given by NCLAT. What are the timelines? It is for understanding purpose, how the court case has progressed. The apartment should be completed in all aspects. This case has been given on 4th February 2022. Should be completed in all aspects. Possession has been handed over, we have seen, during CRP process itself. But what is this? Other facilities, amenities, common amenities, and all internal fit outs of electricity, water connection should be completed by 30th July 2020. The financial institution and banks should be paid simultaneously. Allottees are directed to deposit the entire their balance amount and pay 90% without penal interest if not deposited. See, since there is a delay from their allottee's side, in some cases, they can pay the amount without any interest. So they have given the timeline. All the common thing, another thing needs to be completed with some deadline. This verdict has ended. If the promoter failed to comply with this commitment, if they haven't done, the normal CRP process will continue. To elaborate further more on this one, this people, see if you're seeing that for 4th February 2022, the verdict has been given. After that COVID started, so there were extension has been given. So those things are apart, not for our say reverse CRP process. I'm just giving it for information purpose. Okay, now we will come to this verdict has been given. I'll just recap the verdict. Okay, first ruling is that they have said without third party intervention, it can be executed. has one further, they have said they have the power of experimentation in case of economic legislation. Haircut is not permissible. And further to that, they have said make it for real estate project, let us make it as project specific. This is one other one. And added to that, secured creditors cannot be given preference. That is also they are given, and they are given certain timelines also. Now we will see what is this case, how this case has created some anomaly. We will see what are the issues it has created. Okay, the conclusion reached, it has pros and cons. It is not that the entire thing has been deviated. It is to some extent it is accepted. We will see that one. The conclusion reached by Honorable Neklat have balanced the rights and liabilities of all stakeholders. It has considered, however, the approach adopted to reach the said conclusion is not proper. Why not proper? Because the code has been deviated. What is said in the provision of the code has not been carried out, right? Okay, what are the things if you see? Resolution applicant has not come into picture. This person, a financial creditor, section 53, it has its own problem. What does it say? It has been a secured creditor needs to be given preference. But are they allotted secured creditors? No, it is not there. So we will see those things in detail. What are the issues? What can be done? We will see. The following are the few anomalies in this decision. Okay, reverse CRP process and judicial legislations. Okay. Well, as I said earlier, they are judicial body, NECLAT, NCLT, or judicial bodies. What powers they have? They have the power only to interpret the law and not legislating it. Okay, why not legislating it? Because if you see to an act to be passed, it requires majority of various political parties, right? Here, just like that, NCLT came, NECLAT came, NECLAT passed an order which is not as per the provisions of the code. How to accept it? The question rises, right? If you see, the alloters are being satisfied, correct? But can I take the same thing and go with the other? Can I adopt the same thing in other cases? Question, there are multiple questions which are arising. They haven't done what they have to do. The judicial body haven't done what they have to do. Therefore, the reasonable restraint should be exercised, especially when excess of such power, which power may lead to an outcome which is inconsistent. What I said earlier is that it is not as per the provisions of law. Okay, it is respectively submit the powers exercised by Honorable NECLAT or in violation of the said principles of law. Agreed? Correct. We'll see. Now, if this is disturbed, what will happen? Every other judgment also can take the same thing. They can deviate, right? If it is accepted, we'll see. First, what are the things? The code does not prescribe the process wherein debtor and creditor resolve the insolvency process among themselves. Arrangement, compromise was not given in the code at all. Correct. Thus, therefore, the introduction of such process is a classic case of judicial legislation, because what has happened, the judicial has taken the legislative nature. And another thing is that third parties are not allowed to revive the company. And that is also, it is not as per the provisions of the code, which is against them. So that is also deviated. Again, the provision of the code is deviated. Arrangement between the corporate data in order is inconsistent. These are the things which we have seen. Without the involvement of the third party, even though it is a welcome approach here, we don't know whether the same thing can be applicable to other scenarios also. Here it is quite good, quite accepted. Is it this reverse CRP is equivalent to withdrawal?
And before that, can I again ask a question? Maybe because I am interested in this project.
Yes, yeah. Which side to go?
The CD, so ma'am, in a normal CRP process, once I get a resolution applicant and the COC approves it, the resolution applicant upon order of the adjudicating authority becomes owner of the CD.
Owner
right? Of the CD.
Okay, correct.
Now, in this case, then the promoter is coming as a lender.
Lender.
And
okay.
we are buying individual flats. Who is the owner of the CD now?
IRP, here IRP alone.
IRP will not continue forever. IRP is only till the time resolution plan is approved by the CD. Once
Yeah.
the resolution plan is approved by the AAA, IRP is out and the new applicant, resolution applicant becomes the owner and runs the CD and owns the CD.
Correct.
Is
See,
the IRP going to be the permanent operating this project? I'm not clear about it.
yeah. Okay. Here, as I said, this case started during 2019. Year 2019, it started somewhere August. Okay. IRP Manish Kumar Gupta was appointed. He continued as an IRP till the case was closed, which is closed on 4th February 2020. He was still an IRP because COC is not formed. So he was not promoted as an RP. He still remains the same. That's what it has deviated from the regular CRP.
When will his role end, ma'am? Who
Pardon?
will own the CD now? Because the promoter is only a lender.
No, promoter is a lender. The management is still in the hands of IRP. IRP,
At some stage, IRP has to go out of this company.
IRP, if you see the wordings of the provisions, still an RP is appointed. IRP will continue as the RP. IRP will continue to manage.
At the far end, once my resolution plan, in a normal case, I'm not talking of this case.
Okay, that's fine.
Once my resolution plan is approved by the adjudicating authority, I as an RP or IRP relinquish my office and the new resolution applicants now becomes the owner and runs the CD, and this is out, the CRP process comes to the end.
Correct, that's regular.
In this case, when will the CRP process come to end? Who will become the owner? Because promoter is only a lender.
Oh, here the CRP process hasn't come to an end. The buyers are given Winter Hills allottees are given flats.
So when will it come to end? How will it end?
Okay. Only thing is that the rest of the thing, if you see the first few slides I have shown, the case is still going on. For this particular project, that is Winter Hill, reverse CRP has been taken. For the others, it will take the normal route and it will end there. So that is separate route. That's what I said.
For others, in this case, Winter Hills, CRP has, so you are saying in Winter Hills, although in 2020, as per your suggestion, your slide, everything was handed over, the CRP process is still going on. Until when, in your opinion, it will go on? 330 days are long over.
Yeah, it's actually 330 days they are saying. In our cases also, it has exceeded 330 days. This 330 days is only for, as of now, it's for book alone. There are multiple cases which is going more than 1 year. Okay.
So I'm saying in those cases, at least we know that the CRP process will get over once the adjudicating authority approves the resolution plan. In this case, how do you see the end of the CRP process?
The end of the CRP process, if you see, as per the cases, what is given here is that they have given NCLAT has given an option to go with the CRP, reverse CRP process. And it has been taken care. And if you see, even the cases are going now. What are the cases? If you see, there are other persons. They generally, after the cases has been declared, the other operational creditors, other financial creditors raise some issues against the CRP process. Those things are still going on. Okay, once my thing is that once the project is completed, Winter Hills is completed, and all handover has happened, then it needs to come to an end. It is a reverse CRP process because it will not take the route of regular where you, as you expect, some RA will come, nothing like that. This will have an open route. So they are getting into a compromise arrangement and it is taking a clear route there.
So we have cases of more than 2 years also in CRP. Apart from Jet Airways, which every one of us know.
What do you?
Beyond 2 years.
It goes, the case goes.
I was just asking, you see, whether it is 2 years or 5 years, the normal CRP will end somewhere.
Where is the end you are asking? The project is getting completed.
This project, how do you see the process coming to an end? I mean,
process coming to end once the integral projects is completed. I have given you some deadlines, right? Once the deadline is completed, then it comes to an end here. See, we can't, that's what we are saying. It's not a regular CRP process as you expect. This is a deviation from the regular one. So,
Madam, in your slide, the regular process is over long back in 2020. If you go back to your 2, 3, 4 slides, I mean, few slides back, yeah,
This one.
here it is.
yeah, this side.
Everything is over by 30th July 2020.
Yeah, that's what I said. No, because of this COVID, they have obtained extension, and after obtaining extension is also permitted for the good
Yes.
paper. If it's
Till what time it is extended now?
see, they
Okay,
have extension. Various months they have got extension. Even for first one time they have obtained extension for 6 months.
so
Because
right now,
right now the
I'm
case.
saying, ma'am, this particular paragraph that you are saying, a flat completed and all those things that you have written,
Okay.
these deadlines have been extended and they are still not completed. Am I understanding it correctly?
Yeah. See, this handing over, few works are pending. Added to that, that's what I'm saying. See, whenever if you come to a case, it will not end there. Other people will not be silent, right? Because they are also affected because of the winter hills. Because here the only person who is benefited is the allottees. We don't know the entire thing, whether there are furthermore financial creditors, is operational creditors, they are not paid anything. So we don't know the exact situation. So only the allottees are preferred here. The case doesn't have that details also. See, if you see entire thing I have read, it says that this has been extended and it still goes on. Some more cases are going on. I'll just, I can share that one also.
Sorry, ma'am, to disturb you. Please go carry on.
See, whether we need to see whether it is a reverse CRP or withdrawal. That's what we have seen here. Withdrawal means entire person has accepted, 90% of the people members should have accepted, right? So it is distinct. See, a reverse CRP is distinct. The part is under reverse CRP. This is only an arrangement, okay, under the CRP process where the resolution professional is involved. So third party, no third party. Resolution professional, corporate data, and the applicant and the persons related to the applicant. On the other hand, it is a reach a provide settlement without the involvement of the resolution professional. There are two concepts. This is not withdrawal. So that's what we mean here. We'll move to the next another point, which is we have seen earlier, experiment on judiciary. The words used in the neglect is again subject to various discussions. We'll see that. Further, it is pertinent to state that reliance of honorable neglect on the decisions of pioneer. This is a case they have quoted, and they have said they have the power to experiment on judiciary. We will move on to that particular case. It's a pioneer urban land and infrastructure case to justify whether they have sufficient power to experiment. Since the code is an economic legislation, they are saying it is there. It is not proper. Okay, why? We will see that one. Honorable Supreme Court in that case, pioneer case, did not confirm the power of experimentation on judiciary. Because there, when the NECLAT has given the order, they said the Supreme Court have given power to experiment on judiciary. We will read what is the case, that is, in which case they have used a word and what are the words used there. Those things we will study in detail to understand more on the subject. So, okay, it is clearly recognized and upheld in the legislation right to experiment in the economic legislation. We will see. Okay, first thing, where it started. It started in the COC of SR Steel India Limited versus Sadish Kumar Gupta, where Supreme Court has given these words. What are the words? Why it is important? I'll explain you. Okay, in SR Steel, Supreme Court has given Swiss ribbon case. It has taken Swiss ribbon. In that thing, with what the words I have highlighted here at pains to point out. Referring inter alia, because at various American decisions in para 17 to 24, the legislation must be given and free play in the joints, which when it comes to economic legislation. What does it say? Okay, in American decisions, what they are, the judiciary is given some freeness. Free to play. When it comes to economic legislation, they can little deviate, they can say. apart from the presumption of constitutionally which arises in such case, constitutionality which arises, similar thing also, the constitutionality, the validity is questioned. The legislative judgment in economic choice must be given certain degree of deference by the court. They are saying, they are giving an option. They are not saying it has power to do experimentation. That's what it is given here. We will see more on this in 120 of the said judgment. We will see here. What does this 120 para of that Swiss ribbon says? We will see. Insolvency is a legislation. Correct. It is a law which deals with economic matters quite well accepted. In the largest sense, deals with the economy of the country as a whole. Okay. Earlier, this code, we know very well, we'll see some backstory of this code. The code has come into picture after various flaws and multiple acts, okay, to overcome that, to subsum that, alone the code came into picture. Why we call it as a code? Because it has everything in itself. Because right from the problem and how to address everything the code has. So that's why we name it as code, because it has multiple laws together under one single frame. The experiment contained in the code, judged by here also, when the code came, it also taken up various issues which have been unaddressed earlier and tried to address it, judged by the generality of the provision and not so by crudities or inequities that are pointed out by the petitioner passes constitutional muster. To stay experimentation in things is a grave responsibility, and denial of right to experiment is fraught with serious consequence to the nation. See, actually, they are saying that the judiciary requires experimentation. If not, there could be some problem. That's what they are saying. But they have stated the statement in such a manner, they should be given experimentation. They then say they can experiment. There is always a problem is there. It's a reading of these words and what is given by NECLAT. We have also seen that the working of the code is monitored by central government, by expert committees. Whenever certain things are required, modification, it will be taken by the expert committees. Okay, amendments, that's why we have amendments. Those things are there. But still, jumping, now what has happened is that NECLAT has jumped into the conclusion. Okay, what is the role actually? They are supposed to say whether the law has been interpreted correctly or not. But over and above, they have given a new route, reverse CRP. See, just think then in that case, we have, in that case, if I want an act to be passed, I can make an act like with some flaws. And if it goes to court, it will have a different thing, which is not in the law at all. If the same thing is adopted in other cases, how far the court cases in India will survey, we don't know. Then the judges are given more power than the political parties. So those things also could be if this thing is adopted for various other cases, if this is taken as an example, then that may lead to difference. Judiciary can take the legislative powers. Okay. In view of the observation of the Honorable Supreme Court, we experimented as whether the corporate insolvency process resolution can reach finality without the approval of the third-party resolution plan. It is questioned, right? See, that is the Act says this is the flow, this is the process, these are the number of days which is required. But here, what has happened? Everything is deviated. Okay, it is in this background the constitutional challenge to the amendment will have to be decided. Here, it is questioned alone. Also, justification premised on the impossibility to accept a haircut. Again, it is said, right? Haircut is not permissible because every case we can't take it up. See, Winter Hills, if you take, they are almost in the completion stage. So if someone has funded, so it has taken that route. Come to another case where it is halfway. I have seen cases where it is for years together, the allotors are not given any interest, no, this repayment is not there, even the refund it is not there, they are still the sufferer. This is one such case which is in the completion stage. Only thing is that the Winter Hills is in the completion stage, so this process can be exercised. Can we adopt the same thing to others? We have to wait for the code to get amended. It's right now the code is not amended. In line with this case came in 2020, February 2020. But by the code, this is silent, central government is silent on this one. Even the judgment comes, unless it becomes a code alone, we can apply it without any hesitant, right? If we are applying that, then the court may come and say it is not there, because it is not accepted, it is not even tried in Supreme Court also. So many questions are behind this judgment. So if you see, whether it is legally tenable or not, it is questionable alone. Okay. Then next point is that they have said project specific CIRP. Correct. We will take a simple case and we'll go to a complex case. See, the case is that if a company has one single project, then it is quite good because they would have taken loan from particular financial creditor. Okay. Or multi-financial creditor could be few in number and allotors, and that those people alone will be there. What about if the project is of large sized? You think there could be financial creditor. They are saying project specific. Project specific means specific to the project, financial creditors, allotors, as well as financial institution, banks. Operational creditors specific to the project. Everything is specific to the project. See, some cases it doesn't go as per the rule specified by the NECLAT. Projects are not very specific. There could be cases here project. Another thing we have to see is what is project. The term project as per RARA, which also we will see. See, the project itself has different meanings that also we will see in the next slide. Okay, if the person is constructing large project, what will happen? 3 buildings of more than 8 flats, multiple projects are there. Okay, in that case, how to similarly a large size housing projects divided into 4 phases. A project can be divided into 4 phases. That is also happens, right? And that is also one scenario. Further, all of these projects can be commenced only on the approval of the plan by the competent authority. See, here again, the project builder can get approval for a particular phase alone, or he can get approval for a particular building alone, or he can get an approval for all 4 buildings and he can start the construction. There are multiple situations are there. It is not that thing, it is not very clear. Only Winter Hills alone is not there. See, NCL NECLAT has addressed that scenario alone. It hasn't addressed other cases in general, where multiple phases are there. Further, all the projects we have said commence only after the approval of the plan by the competent authority. Okay. In the light,
can I intervene on it again here?
Yeah.
Sorry to keep.
No issue, carry on.
See, I'm still confused between this project and the corporate debtor. When a CRP starts, the board of directors, powers of the board of directors under 17(1)(b)
is suspended.
Are suspended.
Correct.
Now, board of directors of a corporate debtor or a company are not appointed for a particular project. They are appointed for the whole company.
Correct.
What happens to the powers of suspension of powers of the board in this case?
Okay.
Madam, take one more question from me. If he has finished, I will ask one more question. You finish, sir.
Fine. Carry on. Yes, Gandhi, carry on.
So I have raising 2-3 questions, ma'am. I'm not so clear. One is, how will I do the MCA and income tax compliances for a particular project? Because I have to do it for the company and the company is not under me as an IRP or RP. I will be there for a project. The board is there for the full company. How can their powers be suspended for a particular project? Third is, how will the officers or managers of the company will report to me? Because there could be some managers or officers who will be for the particular project. There will be some who will be doing both this project and overall, like CFO, for example. So how will he report to me? So correct. I'm confused between amongst these three things.
Yeah, okay. We will discuss on
Madam, adding to his questions, should we go through the process of taking it to NCLT for the approval, or is it a straight through process based on the already the pronounced method of approach?
Okay. First thing I'm saying here, see, this is the verdict which is given by NECLAT. Okay, the code has not been amended still. So it is this based quoting that neglect case. We can if you have anything under in a real estate sector, you can make, if any of your clients are of this category, they can make it project specific, and as quoting the case alone, we can flow further. Okay. And in that case, we can go only for this A project. I want to go for CRP. I don't want to disturb other things. So it can be that manner. So it is a new thing. Gandhi sir, it is in the new flow. They are trying to execute. For Winter Hills, for this Umang's Realtek situation, it has been made applicable. Okay. If you see, if that case is the case that Umang
This case, madam, in Winter Hills case,
Winter
whether
Hills,
the powers of the board of directors were suspended or not. I wish to know that.
no, it's not that thing. They haven't given on in the case which I have read in full. They haven't talked about the board of directors at all. The only case, only thing is that they haven't talked about the board of directors. See, when the case was running, when the situation started, when the process started, that is when the CRP process started. I'll just say the flow, how it has happened, and what is the case ruling has happened.
Madam, include one more in that. Is the promoter different from director? In that case, that the directors can be in a different platform. We are talking about the promoters of the company currently. So if I'm not wrong, correct me in this.
Okay, promoter, that is also an issue. See, we know section 29A, which says that the promoter cannot participate in the resolution and in the CRP process at all. Here again, there is a deviation. The promoter has stepped in. Okay, so that is also, see, whatever question you are asking.
No, please. I've understood that portion from your this presentation. For the purpose of Mr. Kanti, I wanted to add it saying that promoters may be different from the directors. So the promoters, you are giving a special provision which you are going to take it to the NCLT. If it is going to provide medicine for the the home buyer, we are going to take this route, and NCLT is going to use this case. If it suits, then it is going to allow. So it need not be the promoter and director could be different. Is what I wanted to bring in for Mr. Kanti's sake.
Correct, sir. And I agree with you. They are two different. My only point was whether 17(1)(b), which says suspension of powers of board of directors, whether that is in force or not, whether board of directors are still, their powers are suspended or not.
Okay, first thing I'll explain, Gandhi, for you. Actually, the case has been taken. We have seen that person, Rachna Singh and Ajay Singh, they are the applicant. Once they have taken the application, that application has been accepted by NCLT. The process starts. Moratorium starts, the directors has been suspended. Only person who has taken up this thing is that, if you see in the earlier thing, the person who manages show is Manish Kumar Gupta. He's not a resolution professional, he's a resolution professional alone. The board of directors has been suspended. Yeah.
Ma'am, board of directors are not for the project. I'm assuming this company Winter Hills will have many projects or whatever Umang Realtek. Umang Realtek is a company CD, and there is a project called Winter Hills 77. I'm assuming that Umang Realtek will have multiple projects. Just let's for assumption. The board of directors are for Umang Realtek, and they are not for Winter Hills 77 project specifically. Will the powers of the board of directors of Umang Realtek, when there is a single project under CRP, will get suspended under 17(1)(b) or not? Okay.
We'll take your case. We'll take a case assuming Winter Hills has Umang Realtek has only one project, that is Winter Hills. If that is the scenario, the board of directors activity gets suspended. If Umang Realtek has multiple projects, for example, apart from Winter Hills, they have other projects also. In that case, we will say this one. If other case, the situation is in this case, they are not supposed to involve themselves in Winter Hills. Only interim resolution professional or resolution professional can take up the scenario. They can alone manage the show, because it is that they have taken as per the code. That's what it has prevailed in this particular case also. Directors has been suspended. Suspended directors for Winter Hills is suspended alone. They have not been given power. Only the promoter, he has infused money. And the show has been run by interim, going concern concept has been taken up only by the resolution professional.
You are saying the board of directors of Umang Realtek have their powers with respect to the other projects of Umang Realtek, and their power stands suspended in respect of Winter Hill 77.
Correct.
That's how the order says, ma'am. That's
order doesn't have that thing. See, the thing is that they said that only this interim resolution, they said this two person, right, a resolution applicant, they have to give 2 lakhs to run the show. So it comes to the person who is a person, Manish Kumar Gupta. He has been given just 2 lakhs to run the to take the concern as going concern. Is this 2 lakhs suffice? No, it is not at all suffice to build, to continue as a going concern. He requests fund. So as an interim funding alone, this person who has come into picture without accepting this RA, that is resolution applicant area, this Uppal Housing has come into picture. They have funded. One of the promoter has funded and made the construction as a going concern, and the project was in the hands of the Manish Kumar Gupta alone. Directors are not back. Okay, that's given in the case.
so likewise the officers also, let us say CFO, who will he report to?
He will report only to Manish Kumar Gupta. He will report in
No, but CFO is for the full all the projects.
Correct. See, actually, the scenario at reverse merger, if I take A, B, C, D 5 cases, see, A, B, C, D 4 cases, A, we assume A as interface, which can be revived. Okay. Other 3 cases, B, C, D cannot be revived, can't be revived. Okay. If it can't be revived, in that case, it goes for normal CRP. Here, the entire board of directors is suspended alone. Reverse means I'm giving life to it. See, that's what it means, right?
Right, ma'am.
Okay, coming to the next question, how to file this MCA, IT, those things. Only the case is that now only for A you will be showing, that is for Winter Hills, you will be having some income, some loans will be there. When you are filing, you will be filing as a whole alone. For Umang alone, you will be filing your project thing. In IT return, ROC will be for that thing alone. Okay. Gandhi, is it audible?
Yeah, you're audible, madam. Please go ahead.
Okay, fine. The next thing is that here, see, this is an experimental thing. That's what I'm saying. They have experimented in Winter Hills. See, whether this can be replicated for other cases or not. See, the code is silent. See, after February 2020 has happened.
Madam, for the benefit of Kanti, the website of Umang is still showing it is under the CRP process, and the process is going on, and it has got the update of the NCLAT, and it has also got the update of the various status of CRP.
Yeah.
Thank you, sir. Can you put that website address on the chat box, sir? I will like to see it. That's very interesting.
This is the thing
that madam has presented.
This is the case. If you see this Umang, this pink color thing is the thing. See, they are giving, it's going on still. Some more cases are giving, it's not because of the, see, this IRP still stands as an IRP.
Madam, where is the pink color thing you are saying?
Can you see my screen?
Yes, I can see those black and blue. Nothing pink.
I'll share again.
Sorry to disturb you, but thank you for that gentleman also to show that website.
You are welcome. We are only the 2 active participants. You don't worry. I'll always be with you.
Okay, good. Can you see the screen?
Yeah. It's not. If you can just. Yes, it is there.
Here
so
where is still.
Where is Umang's website address?
Umang's website address I can mail you. Doesn't matter. I can share with you. See, this is the, if you open this thing, the first slide is, the first web page shows this alone. Okay. And next question you are asking.
umangrealtech.com is the website.
Okay, thank you, sir.
Okay, and the other thing you are asking is that still he is having the designation as IRP alone. Since yours is not formed, he has not been given RP status at all.
This gentleman is very helpful, actually.
Okay.
Spoken to him.
I'll move on to the next slide.
Yeah, please.
Madam, you want a short break? You can do that.
Yeah.
Hello.
Okay.
You want 5 to 10 minutes break? You can take, madam. You are continuously taking.
Okay. Thank you. Then
Incidentally, you can give us also break.
Thank you. Okay, we can resume by 3:10 then.
Sure,
350.
Great, madam. Thanks.
Thank you. Hello?
Yes, ma'am.
Yes, ma'am.
Yeah, can you see my screen?
Yes, ma'am.
Yes, ma'am. The screen is visible.
Okay, fine. The first problem what we had discussed is that experimentation on judiciary was the thing we have discussed. We'll move on to the second issue, which will be discussed is that projects. Project, the word they have given here, there is a project. It could be a single building or piece of land. When it is simple, it is easy to apply Winter Hills rule, case study. How about when there are multiple phases? How is it the same can be applied? It is again creating a question mark, because the thing is that when it is not one thing, it is not one-to-one. So that means it is not that financial creditor has funded only that project. He would have funded multiple projects. If you take the case of OC, he would have funded multiple things. He would have supplied in general to Umang. It could not be Winter Hills. There could be cases even they would have supplied Winter Hills exclusively. In some cases, they gave only Winter Hills. So certain case thing is that how to apply it one-to-one, how to make it project specific. It is a question mark when we come to practical application. See, when it is simple, no issue. When it is complicated, that is when there are consortium of lenders are there. In that case, how to adopt this case study? It is again a question mark. See, for this alone, it is said that the code should be amended in line with these things. How to adopt it? How in this case, what is the methodology? How it has to be divided among this OC, FC? Those things are not still clear. The thing is that particular case has been resolved, but it is not the thing. We can't take it for all cases. So there are multiple questions which are unanswered. I'll just bring it other questions also. Okay. Firstly, it is not possible to derive or apportion the exact amount of finance used for development of a particular phase when the finance is used for purchase of raw material for the entire project. So these are the practical difficulties which we will be facing. Further, see, what is the thing is a maximization of the assets of the corporate data. That is one single line through which the IBC travels. But if you see, this is because a consortium and development of different projects are maybe interrelated. If I say project, how to apply for that particular project, how to categorize it, then in that case, the option is that every project should have its own balance sheet, own P&L. So in that scenario, then we can try to adopt the cases. Okay. If a project has its own balance sheet, then I can make things clear. He is my data. He is my OC. He is my FC. I can have a better understanding in that case. If I have better understanding, then I can make the CRP process project specific. Till that time, we will have multiple issues. See one more example also. In large sized project, where the first phase involves construction of 2 buildings of 16 apartments. Second phase, 1 building of 16 apartments, swimming pool, children park. Half completed. In that case, how to take up at this one? That is, swimming pool is not completed, children park is not completed, first phase is alone completed. So many issues are there. Okay. In the late, if it is started for the second one, we don't know how to handle the other one. Like Gandhi sir said, there are many questions this judgment has raised. So only my concern is that it is that the code has to be amended. Then this point also, Gandhi has raised no preference to secured creditors. Agreed. See, this is what again, as I said, this is not in line with section 53. It is 100% deviation. Okay, only thing is that this judgment has been given in such a way, allotted should be protected. Correct. What about the others? How come they will be, they should not be the sufferer, right? The Article 14 they are talking about. How come Article 14 is executed in full? Because one is alone given preference, others are neglected. So here, that's what this judgment has given rise to various other questions also. No preference to secured creditors. The primary source of value in case of real estate bankruptcy is that flat construction or under construction. What does it mean? See, if we take a project for a company, real estate sector company, what will be their assets? Most of them will be their inventory. Inventory in the form of land or flats, which is constructed or under construction. So that will be their assets, right? See, this judgment says that this flats needs to be given to the alloters. Okay, first level of preference, I'm just deviating from section 53 and I'm giving the flats to those alloters. Okay, then during that time, in this case, like JM Financial, some would have financed. So he takes a 30%. So for construction, they require fund, interim finance, they require fund. Those are the needs will be met first, right? Then what about the persons who have funded earlier, secured creditor? There is a denial. Correct. So what has happened is that the secured creditors are left remediless, as of no means of recovering dues would be left. So actually, after paying those people, interim finance people, because it is considered as corporate insolvency process cost, right? So they have to be given first thing. So after that, a lot is additional one insertion has happened. Then what will be available for the secured creditors is a big question mark. Okay. This approach may be indeed act as disincentive. It is not, because in that case, what will happen? The lenders, that is bank, financial institution, will not offer loan for the real estate projects, right? It will happen, right? Because they don't have protection, because now they are protecting because they are saying them as secure. Are they secure after this judgment? It is a question mark. It may also be encouraged secured creditors prefer liquidation. Yes, correct. Because in CRP process alone, these people will be getting preference. Coming to liquidation, they may prefer only liquidation. In general, also, if you see financial institution and banks are preferring only liquidation, because only liquidation alone they can maximize the amount. Then and by a regular CRP process. That's why we have seen earlier 47% of the cases which has been dealt so far has taken the liquidation route. It happens, that's the reality. See, the code is accepted, well accepted, but it has its own flaws. It can be corrected over time, because as such, our business are not tailor-made. We innovate new things. We find even everywhere we innovate things, even whether it is income tax or companies act, we find some new ways to do things better. So everything doesn't have a solution by this code or by any law, right? So there will be gaps will be there that needs to be properly addressed. That's what one main requirement. Okay. It may also encourage the security. We have seen this one, liquidation alone they will prefer. Then the next point they have given there is right of allottees to seek refund. What they said blanket ban. No. Okay, fine. Because it is not proper, because there could be a fraudulent persons also may take up the CRP route and make things more cumbersome. To avoid that, they said no. Okay, is it no? How to, whether it is strictly no, then they have given one more explanation also in the judgment stating that if the RP or IRP can find a buyer for the apartment already allotted to a particular person, if it is there, it can be taken. In that case alone, refund can be given. That's what the judgment says. Okay, but this may not create undue hardship for them. I can't go for refund. Okay, I have to wait. In this case, see, this case is not applicable in all cases. case, what has happened is that he was able to complete the project before the CRP period, that is 180 days. The situation is that here they were able to complete. Can it be the same case in others? No, it can't be. We can't expect one person, promoter, if he's willing, he can come. If promoter is not willing, it cannot be taken care. So the project, he cannot go for refund, even if there is a delay. RARA says he can claim for refund. But once they enter into the CRP process, they don't have the option of getting refund. They have to hold unless they get a buyer for the apartment already allotted. What are the problems could be? Because for this, how many number of years, whatever it may be, I have to wait. I will not get any interest. I have to pay the rent. I will not get my flat. Everything will ends in a question mark. That particular case, whether it has universal applicability, it is a big question mark alone. Okay. Then we'll say this promoter participation. Here, what has happened is that there was a promoter who participated in funding. Correct. But this is the case. But the current regime, what does the current regime says? the promoter or the person in charge of management or control of the CD. He is not eligible to file the resolution plan. Here, they are not eligible to file the resolution plan at all. Okay, if he is subject to some conditions. Firstly, its own account, that is CD account or the account of the corporate data of which it is a promoter, a person in control is declared NPA, at least only 1 year, he has to wait to take up this one. Secondly, if the person has been a promoter, a person in control of the corporate data, and during which preferential, extortionate, fraudulent transaction has taken and which stands adjudicated. So in that scenario also, he cannot take up that thing. But what does the reverse CRP says? If a promoter, without the involvement of third party, if he is interested, he can infuse fund and he can run the show. Is this not against the provisions of the code? Yes, it is against the provision of the code. So a large number of promoters are in person in charge of the control of the corporate data are not falling under the opposite NAIRO criteria, continue to participate and file the resolution plan. Okay, even though the alloters don't have confidence in them. See, in this case, what has happened is that the promoter, even if the people are not having comfort zone because they have a delay, they have swindled the fund or they have invested somewhere, in spite of them, the promoter will infuse a fund. Again, for what purpose? To delay further, to be out of CRP process, some gimmicks can be done. But real thing, we don't know how far it's going to favor them. This is another issue we will be facing. Okay, fine. We will, so far, whatever we have seen is a negative part of that. Doesn't mean everything is negative. There are some pertinent plus also there. We will see, then we can conclude the thing. Okay, see, this is inconsistent with the present regime. Correct, accepted. Certain things are not as per the provisions. Whatever we have read will not be there. Okay. Inconsistent, agreed, but again, it is not that thing, it is not the new. It may be new for India, but it is not new for the other countries. See, what is the thing is that they have introduced a new concept, voluntary restructuring negotiation process. That is the thing they have introduced. It is saying that voluntarily the promoter can come negotiate and give life. Giving life is quite accepted, but it cannot be given life to all other projects. What is the stage of the projects, where they stand, so many things matter. Even the promoter says he will infuse fund. How long is going to infuse fund, we don't know. Because we have seen in this particular case, it's that 143 alloters are not giving further fund. So they are not taking up it further. In that case, it is quite accepted, but it has its own flaws. Next, this voluntary restructuring, it is new to India, but it is not new to UNICITRAL. UNICITRAL, United Nations Commission on International Trade. Okay, this approach has been adopted. It is not the one new. It is new to India, but it is not new to other countries. What does it say? Under UNICITRAL Legislative Guide on Insolvency Laws, is similarly progressive concept of reverse CIRP process, wherein the corporate data and creditors enter into an arrangement. Same thing. It is taken from this UNICITRAL Legislative Guide alone. Okay. Only problem what we are facing is that how to adopt it universally. To make it universal acceptance, it has to be amended in the code. This is what I'm repeating again and again. Because if that is said, we may have questions. At least we will have questions in such a way there could be some amendment. They can make it strengthened. Okay. It is an exception to the formal process of insolvency. And this can be accepted only when the creditors are low and formal insolvency process. Because we know that if I go to insolvency process, it will take time and sufferance of the people are also there. And the interest of the stakeholder, this is quite good. But again, if you see, I have to see whether this scenario can be replicated for the other projects. Is the situation similar? If the situation is similar, it is well and good to accept. If not similar, then we have to depend on the code or the amendment to come to a solution. Okay, then what else will happen? Then the resolution professional or interim resolution professional will approach the appellate tribunal to get their advice. That's what it can happen, right? Because the code is silent on that thing. The next person to approach is the appellate tribunal. They can alone guide us. Okay, See, therefore, such an approach would be codified by the legislature. And in order to facilitate, that's what I'm talking about. Eligible, they have to give various terms, eligible data. Who can take up this one? General provisions, how, to what extent specific provision is applicable, to what extent general provision is applicable, those things are there. What if this dissenting creditors will be there? That's like Companies Act, we have dissenting creditors, that is also needs to be and addressed here. Effect of failure of negotiations. What if negotiation fails? Similarly, similar in line with corporate thing, section 232 of the Companies Act merger and 233, 234. Similar line, this code needs to be amended. Okay, this introduction is quite beneficial. But again, the thing is that it's just nearing completion, it is quite good. If it is in the halfway, it has not been started yet. In that case, how long I can wait? Still, my question arises whether the promoter, after infusing fund, will he continue infusing fund till the project completes? Because insolvency professional can run the show. They can get interim finance, but the other person should be ready to infuse. If many questions are there, if the many questions gets an answer, this is quite good. Okay, another one is also there. See, we are saying right now, if you see blanket imposition, ineligibility of promoters. See, here also we have to see a positive thing. Really, if a situation comes like Uppal, that is, Uppal is a person who has agreed to infuse fund, is one of the promoter. If a person like him comes, then it has to be accepted. See, that's what, if you take a thing, it can be accepted. There could be pros, there could be cons. We have to see. Here, if you see, here the positive side, Uppal has accepted, the promoter has accepted, take it up genuinely to take it up. The project has been completed. It is accepted, right? So similar, same thing. The logic is that similar thing if it is in the end stage and if it is a simple project and the person is ready and he has already funded and moreover added to that on the based on the completion thing, another person is also ready to fund with some conditions. In this case, it can good to go situation alone. Okay, so that is the scenario right now we are having. Then we will see we have to come to a conclusion here. What is the conclusion is that what are the things which we are looking for is that this IBC has been always missed. We feel so far it is a misfit for real estate sector. Because as said earlier, it can be seen project specific because the code has to be certainly modified with regard to real estate sector. Not only for real estate sector, there are other things also there which also need some modifications. Right now, we will see with regard to real estate sector, we cannot have the umbrella approach. Here, it requires project-specific approach with some amendments and some necessary questions to be answered. Okay, so what is whether 1 out of 5 needs to be taken as CRP process, and what about the rest 4? Whether they will take whether it will be run as a regular business or they will come under a normal CRP route. Those things they have to make it things very clear. Okay, the thing is that already RARA has come into picture to solve the problem. Consumer protection is also there. IBC is also there. So many things are there to protect the home buyers, but the problem keeps going. Okay, because there are repeated violations from their side. So it is the case is that insolvency, this code can be strengthened further in such a way to some major extent. This can be avoided in near future. That's main thing which needs to be addressed. Then if you see recognition of home buyers as financial creditor, limit on the number of alerters for initiating class representation, judicial experimentation in the form of a few debatable concepts. They are debatable alone. But if you see this is to end, I'm saying this is accepted, but provided the code and various other questions which has already arisen, if it is addressed, this reverse CRP process can be adopted and it can give some solutions to some real estate sector. This is from my side. Anything from your side, just put it down. Any questions from your side?
No questions, madam. Thank you so much. It's been real wonderful session. Thank you.
Thank you. Thank you.
One request, please share the presentation.
Yeah, sure. Okay. Thank you.
Ma'am, there are no further questions. Then can we just wind up?
Yeah, sure.
Okay. Ma'am, on the behalf of ICSI IIP, I would like to thank you for sharing your practical understanding on the subject. And I hope we keep meeting in these sessions in future as well.
Okay. Thank you.
Thank you so much, ma'am. Thank you all the participants.
Ma'am, will you send the clarification that you had told me?
Yeah. I'll do that.
All right. Thank you.
Thank you.
Thank you.
Thank you.
Can we leave it?
Yeah, you just share your number alone. So my mobile number is here. You just share your number so that I can answer there.
It's 98
988
98113066829. I have written on the chat box my number.
Okay. Chat box. Okay. Thank you.
Should we leave now?
Yeah, you can.
The session is over
Yes,
for.
sir, you can.
Yeah, over, sir.
Yes, sir, yes. Thank you.
Thank you, ma'am.
Thank you.